So that's been kind of all over the place lately.
Well, so here's the concept of joint employer, and we see it in a lot of different contexts. I mean, in Title VII, we see it all the time. You've got a temporary staffing agency who has employees on its payroll in the factory of, a manufacturer. And the employee who is working for the staffing agency feels like he or she is being harassed. And so they file legal action, not only against their W-2 employer, the staffing agency, but also the manufacturer, because ultimately on a daily basis, you've got a boss from the manufacturer who is calling the shots, right? They are in control. And so there's joint employer liability. Well, there's been a similar concept under the National Labor Relations Act, right? If there was actual control, then the law said that you may have joint employer liability.
Said. That's
Exactly.
what it used to say.
But under the last administration, the board took the position, if there could be control, then there could be joint employer liability. The international headquarters for Burger in the Box could be responsible for, what a, say, small family-run business in, Hayhira, Georgia, right? ABC Family Enterprises doing business as Burger in the Box. The international headquarters could be a joint employer with a small restaurant in rural Georgia. And the board said that seemed reasonable to them. Ultimately, the new board immediately came in and reversed that in one of its decisions. Now, the problem was that there was at least a perception of a conflict of interest because one of the board members who voted to reverse that had been a partner in the law firm who had litigated the prior case. And so the decision was reversed. But the good news is the board is at least considering through rulemaking, making that change.
All right, so kind of a related concept, independent contractors.
There was a new case, a super shuttle case, where again, what the board did is they looked at really, how independent was the super shuttle driver? And if somebody has the right to, say, for example, create their own hours, decide whether or not they're working, whether they're able to subcontract the work, whether they pay for their own supplies, whether they assume the risk of profit or loss. I mean, those are classic indicia under, both tax and employment law of somebody who is truly an independent contractor. And so we do have some good news on the board that at least now they are open to the idea that there are people who perform work for services that are not subject to the National Labor Relations Act and truly are independent contractors.
Okay, well, let's move to what's left. Quickie elections.
Quickie elections. All right, so for those of us who have been doing this for eons and eons, once upon a time, an election cycle was up to 60 days.
Right.
And then certainly before I started practicing labor law about 20 years ago, it was down to about 42 days. Now, there was absolutely nothing magic in the law that gave an employer 60 days or 42 days. I mean, ultimately, the way that it worked was this, that a union has up to a year to work on your employees. And generally, they use a thing called the Blitz campaign. And the Blitz campaign, the idea is to keep everything underground so the employer doesn't know it. And ultimately, the employer gets waylaid at the very last minute so they can work on employees for up to a year, because union authorization cards are good for a year. And then once the union filed a petition for an election with the National Labor Relations Board, well, if the employer exercised all of its rights, for example, the right to demand a hearing on the bargaining unit composition, the right to submit post-hearing briefs, the right to appeal it to the full National Labor Relations Board, if the employer jumped through all of the hoops, then ultimately the process probably would take at least 42 days. And so really, as a matter of policy, what the board generally did is they would give the employer and the union the right to be able to negotiate generally around 42 days. Under the last board, they eliminated a number of the procedural rights that employers had. Now, the practical effect of that was this, that it took what was basically 6 weeks to clear up what people have been telling your workers for a year. It took it down to somewhere between 13 and 21 days. Frequently, management, by the time they find out about it, we're already 3 or 4 days into that 13-day cycle, right, which means you may have a week or so to clear up a year's worth of misconception and a year's worth of the union suggesting something to the employees that may not necessarily be grounded in facts.
Right.
Which, earlier we talked about the spit rule. I guess one other thing we ought to share with folks is this. While you can't spit on your employee, or you must follow the tips or avoid the pits, whichever you prefer, here's one thing that a management can do. You can talk about your foe. And here's what that means, is you can share facts, you can share opinions, and you can share examples or experiences. Now, you can't make something unlawful lawful by inserting the word opinion in front of it, like, it's my opinion they'll move this work to Mexico if you unionize. It's certainly my opinion that we are better off working together to beat the competition than working against each other through a third party, right? You can share an example. I was in a facility and the facility was unionized and ultimately the facility shut down. So if the folks that are talking to you are suggesting greater job security, well, I'm here to tell you perhaps what they're telling you is not the truth. You need to go ahead and do some research on them, or facts. 1 out of every 3 workers in America in the private sector was unionized in the 1930s and 1940s. Last year it was, as I recall, 6.4%, or about 1 out of every 13. If these guys and the unions were doing such a good job for the American worker, then wouldn't their membership be going up rather than be going down? And so you can do those sorts of things. Right. The key is in the Quickie election, you have such a short timeline to be able to share facts, to be able to convey opinions, and to give examples or experiences. I mean, ultimately, it made it a very unfair fight from the perspective of, if the goal behind the National Labor Relations Act, if the goal is to make sure that employees make an informed decision before they go in and with a secret ballot determine their own future, well, it's hard to make an informed decision if you've only heard one side of the argument. And at least we're getting some suggestions from the board that we might be going back again to a longer election cycle, perhaps 6 weeks, which again gives both the union and management the ability to convey both the pros and the cons of unionization, having a third party representative.
Yeah, and I think you bring up a really good point that knowledge is power. That's what we kind of always say in all union elections. The decision is up to the individual employee, but really the more you know, the better. Okay, so we've got new policies, and we've got independent contractor and email and Quickie elections. We've got all sorts of things that are looking better for the employers now.
Absolutely. I mean, I think the key is this: for viewers of our show, to spend as much time as you can learning about the National Labor Relations Act. It applies to you whether you like it or not, or whether you know it or not. So you might as well know what's going on. That's right.
But yeah, that's the reason I thought it was important for the two of us to actually meet after 2 years of talking about it, like to actually film this today and to kind of give that background. So hopefully people at least be able to recognize those red flags and recognize situations that could be covered by the NLRA when they come up.
Exactly. And next time, let's not wait another 2 years before we talk to our audience about life and law under the National Labor Relations Act.
Thank you so much, Jonathan. Thank you so much for joining us.
Leigh.
See you next time. Bye-bye.